So welcome back to panel 3 of this very interesting conference day. It's a pity that I can't welcome you here, and Cassandra and I are so sorry about it because it's a very sunny day in London, which is not usually the case, and you would have enjoyed it very much being here today. So for this third panel, we will look at the interface between international commercial courts and arbitration, and in particular in jurisdictions with well-developed arbitration centers. We've mentioned the issue of the interface already in the morning discussions, and we will go into more detail now. I'm very, very pleased to introduce our chair, Franco Ferrari, who is professor at NYU School of Law and the director of its Center for Transnational Litigation, Arbitration and Commercial Law. And you will all know him. He's a very well-known expert on international arbitration, on international business law, and on comparative law. He has widely published on those matters and is editor and member of various peer-reviewed European law journal editorial boards. He has also, and is still acting as an arbitrator in international commercial arbitrations and investment arbitrations, and has, prior to his position in New York, held positions at various universities in Europe as a chaired professor at Verona University, at Tilburg University, and at the University of Bologna. Franco, I hand over to you. Very many thanks again for being with us today.
Well, thank you, Eva and Sandra, for the invitation. But let's skip the niceties since we do not have too much time, and allow us to get to the gist of things right away. As we also heard this morning, the topic of the relationship between the ICCs and arbitration is drawing more and more attention from scholars as well as from practitioners. Allow me to just give one example. It may here in this setting suffice to recall that the plenary session of the celebration of SIAC's 30th anniversary focused on exactly this relationship. On that occasion, different views were expressed re this specific relationship. In fact, some participants argued that even though arbitration relied on courts for certain matters, it would be naive to disregard the fact that the two systems seem to compete with each other. Other participants suggested that the two systems rather complement each other, inter alia, because they have different scopes. Now, these issues, as well as many other ones, will also be addressed here today by our 4 speakers, whom I will introduce only briefly given the time restraints. Barbara Dohmann, QC, is one of the UK's leading commercial CILs, whose practice has a particular focus on international arbitration. She has extensive judicial experience, which for today's session is important, both as an arbitrator and a judge in the International Commercial Court of Qatar. And of course, she regularly acts as an expert in English commercial law. Now, her arbitration experience is extensive. It spans international joint ventures, metal trading, oil and gas trading, and for example, disputes between a state-owned company and a private trading company, North Sea oil drilling contracts, and of course, many other construction matters, such as construction of bareboat charters, alleged breach of charter parties' property, intellectual property, construction, trusts, commodity trading, and family foundations disputes. But many more could be said, but allow me to actually skip some of these because, again, we have certain time constraints. Now, the second speaker, Georgia Antonopoulou, is a PhD candidate at Erasmus School of Law in Rotterdam. Her PhD focuses on international commercial courts, today's topic, and is part of a much larger project on access to justice funded by the European Research Council and led by one of our hosts, Professor Xander Kramer. Since September 2021, she has been a lecturer in international commercial dispute resolution at Birmingham Law School, the University of Birmingham. Dr. Weixia is an assistant professor in the Faculty of Law at the University of Hong Kong and immediate past co-chair of the American Society of International Law Asia Pacific Interscope, if I'm not mistaken. Now, her research focuses on arbitration, dispute resolution, and of course, conflicts of laws of private international law and cross-border legal issues. She has published monographs, edited books, and authored, of course, dozens of articles in leading comparative and international and arbitration law journals. Weixia is a recipient of Hong Kong University's Outstanding Young Research Award and its Outstanding Teaching Award in Law. Sophie Nappert is an arbitrator in independent practice based in London. She is dual qualified as an avocat of the Bar of Quebec in Canada and as a solicitor of the Supreme Court of England and Wales. Now, before becoming a full-time arbitrator, she pursued a career as an advocate and was also head of international arbitration at a global law firm. Sophie is trained and has practiced in both civil law and common law jurisdictions, similar to our other colleagues. She holds degrees in common law and civil law from McGill University and a master's degree in law from King's College, London. Now, with that, I would like to skip the introductions and just introduce the various topics that our colleagues will talk about today. Our colleague Barbara Dohmann, she will refer to her experience both as a former judge and head of the Arbitration Center in Kazakhstan. Georgia's talk is entitled, if I remember, Arbitralization of Courts, and will discuss certain features of the ICCs, including, of course, the ones we're talking about and talked about earlier today. Weixia will reflect on ICCs and the dynamics with arbitration with an Asian perspective, while last but not least, Sophie will say a few words from the arbitrator's perspective on what the emergence and development of the ICCs might mean for international arbitration. Now, this being said, Barbara, I give you the floor for your presentation.
Well, first, I would also like to thank BICL for organizing this very important and interesting event and for inviting me to speak as well. The international civil commercial courts in Qatar and Kazakhstan began their work respectively in 2009 in Qatar and 2018 in Kazakhstan, but both for the same reason. And the reason was that each of those countries wanted to create an international financial center, which was effectively a territory within a territory with its own rules. And in order to have confidence from investors to come to those new, it was hoped, international financial hubs, it was crucial that there should be perceived to exist an independent court and legal system, which was nothing to do with a domestic court at all, from which there was no appeal to any domestic appeal structure, and where the judges were recognized as people of experience and integrity. In Qatar, the judges were drawn worldwide from common law and civil jurisdictions. And I may add that the only reason I qualified to be there was that I had been a recorder and for many years a deputy high court judge, particularly in the commercial court, without judicial experience nobody would have appointed a judge to the panel in Qatar. And in Kazakhstan, the judges are drawn from the common law judiciary of England and Wales, and from some senior counsel equally with judicial experience. Now, I think I can fairly say that in both cases, there are non-bureaucratic rules and very clear and simple and accessible rules. In each case, they include reference to the overriding objective. That is no coincidence, because in each case, Lord Wolfe of Barnes, the former Chief Justice of England and Wales, was the first Chief Justice of those courts. He mainly selected the judges in each case and had a great input on the rules and what happened in the structures of those courts. I can also fairly say, to use the phrase of Sir Geoffrey this morning, that we have end-to-end digital technology in both cases. And I know that in Kazakhstan, we have been busier than ever, notwithstanding COVID, doing everything digitally. It's been a very great success. The languages in Qatar are English and Arabic, and there is a translation facility, of course, when required. And in Kazakhstan, the languages are English, Russian, and Kazakh. And again, there are translation facilities as required. Now, Qatar does not have its own arbitration center. Under the Qatari arbitration law, 2017-2, parties can choose the competent supervisory court. And that includes the free choice of the International Commercial Court, referred to as the QIFC court. So the court would, if chosen by the parties, be the supervisory court and have all the functions and roles of such a court that we classically find. This year, the first instance panel of the Qatari court has explained that this choice is available to people who aren't even established, or even one of them be established in the Qatar International Financial Center, because the opt-in jurisdiction only exists in Qatar if one of the parties is established within the QIFC. But you can opt in on arbitration matters regardless of whether you are established there or not. The other important development in Qatar is that in 2020, new mediation rules were published, and they are very clear and extremely helpful rules. And I was a judge mediator in Qatar in a great banking and building dispute, and it was, I hope, very much a precedent for many other mediations, and I come back to mediations in particular. Now, in Kazakhstan, contrary to Qatar, there is an independent international arbitration center, which is really at the heart of the project, it's right to say. And the 2018 arbitration and mediation rules in Kazakhstan are easily the most advanced in the world. We have multi-party cases. You have consolidation and joinder facilities. There is, of course, a hurdle for that, which a court doesn't have, and that is that the parties must agree. Arbitration at all times is consensual, and therefore you cannot just sit there as the tribunal and say, right, you are joined. You do have to consent to this. But I say the rules are very much advanced worldwide, because we have emergency procedures, we have summary determination, and everything that's been recently developed, like the emergency arbitrator, we have adopted back in 2018. The language of the arbitration is whatever the parties choose, And the arbitrator is also who the parties choose or whom I appoint, because I'm the appointment authority. But we are very keen that arbitrators should be chosen from the legal system in which the parties will be litigating, speaking the languages that the parties will want to speak, and having the expertise that will arise in the conflict, in the dispute, and that includes all the particular specialities that Franco has kindly mentioned at the introduction. They are really relevant and they speed up the proceedings. In addition, both in Qatar and in Kazakhstan, there are great facilities that those countries have invested in and produced the buildings and the IT systems and the staff, multilingual staff. In Kazakhstan, we have made every effort to have a staff that will speak most of the languages that people will approach the staff with. And in addition, we have offered the administration of the arbitration center to be free of charge until the 1st of January 2022 in order to launch us. Now, this seems to have worked because we have, as of yesterday, 624 cases, and that is since the 1st January 2018. The great majority of these cases were mediations, because mediation has turned out to be the most favored form of actually alternative dispute resolution. I would agree that arbitration is not alternative dispute resolution, it's just dispute resolution. But mediation has developed greatly because it saves so much time and so much costs and can lead to such a very quick result. We offer the ARB-Med solution, whereby if mediation hasn't worked, you can arbitrate, of course, if you agree to that, or go to the International Commercial Court. And equally, if you are arbitrating and it looks as if mediation might cut through the whole thing, then you can switch to mediation and switch back again to arbitration if the mediation hasn't worked. Make it clear that contrary to many of our Chinese colleagues, we do not have the same arbitrator than being the mediator or the mediator being the arbitrator. That would have to be so far with us different people. Now, the parties in those 624 cases came from 16 countries. 13 of these countries are Belt and Road Initiative countries, and the Belt and Road Initiative was, of course, announced in Kazakhstan by President Xi in 2015. We also have 12 of the 14 Kazakh regions represented in these cases. The disputes were truly commercial, namely breach of contract, financial disputes, employment disputes, and property, land, business and property center, if you like. But I make it clear that employment is important, and it was also very important in Qatar, because the International Commercial Court has been able there to show what is meant by protection of employees, what restrictive covenants you can really wear if you are in a country where if you can't work there, you have to leave and your family has to leave. It's not the same as if you have a restrictive covenant that looks reasonable in a place like London. So employment is an important part of the court system and indeed of the arbitration and mediation world as well. In we have managed to sign 14 memorandum of understanding regionally and globally with other parties. Now, turning to the court in Kazakhstan, I've already described who the judges are and what the languages are. The court is governed by the AIFC court regulations of 2017 and the rules of 2017, and they wholly coincide in relation to the powers and obligations of the court. The court is expressly given jurisdiction to facilitate effective arbitration. This is in the regulations, Article 26. It has the classic jurisdiction vis-a-vis arbitration that you would expect, all set out in Article 27 of its rules. Thus, the court can stay legal proceedings or dismiss them if there is a valid arbitration agreement. The court acts on questions of a challenge to an arbitrator or a challenge to the jurisdiction of the tribunal, but only after the tribunal has first dealt with those challenges. So the tribunal has competence as we have it worldwide, but if then the challenger is dissatisfied, the challenger can still court. There is then no further appeal. The court also, with the agreement of the tribunal and at the request of the tribunal and of the parties, can enforce interim measures and has done so on several occasions. The court also has power to assist in taking evidence. That is again with the consent of or at the request of the tribunal. So witness summonses, so far this has not happened. Now, the court does have a jurisdiction to set aside an award. What it does not have is any appeal jurisdiction from an arbitral tribunal. You cannot appeal fact, obviously. You cannot appeal points of law. You cannot appeal full stop. However, on grounds which are similar to the, indeed identical to the grounds of the New York Convention, and which are the grounds whereby the court would refuse recognition and enforcement of an award, on those self-same grounds, if established, the court can set aside an award. Happily, this has not yet happened, and I hope it never will, but that power is there, and it's very important as a protection for the parties. And it is very important in the context of what it is that the court is tasked to do under the regulations and the rules, that the judges of the court be people who are really familiar with international arbitrations. They understand arbitration. They have the right instincts in relation to it. And that, of course, has happened when the panel of judges was chosen. I should add that so far
I will have to ask you to conclude because
yes, and that was my last sentence. So far, we have been able to do everything in very rapid time, and with that, I conclude.
That was a perfect way to conclude. So thank you very much for the insights as a member of these courts, and also for outlining what the jurisdiction is in relation to the relationship at hand here, meaning with arbitration. So thank you very much. And with this, I give the floor to Georgia.
Thank you very much, Professor Ferrari. I would like also to thank Pico for the invitation. I will share my screen because I have prepared some slides. Can you see them? Yes, okay. So my topic is slightly different. It's entitled The Arbitralization of Courts. So very briefly on the structure, in the first part, I will discuss whether international commercial courts and international commercial arbitration are competitors or partners, borrowing the title of a speech from the former Chief Justice of the DIFC courts, Michael Huang. Then I will proceed to the arbitration features of international commercial courts, and I will mostly focus on the Singapore International Commercial Court, the Dubai International Financial Center courts, and the Netherlands Commercial Courts. I will also refer to other courts whenever relevant. And the last part are the limits of arbitralization. So which features can courts borrow from arbitration and which they may not be able to borrow? So when it comes to the relationship between these two different forms of dispute resolution, I think there is a Europe-Asia divide. In Europe, if we go through the documents that preceded the establishment of these courts, for example, the Dutch judiciary's plan for the establishment of the Netherlands Commercial Court, now the revised proposal for the establishment of chambers for international commercial courts and commercial courts in Germany, but also the withdrawn proposal for the establishment of the Brussels International Business Court, we will see that, among other reasons, the establishment of international commercial courts in Europe was justified upon the consideration of the vanishing trial. So more and more disputes are resolved abroad or in arbitration, and therefore public courts deal with less international commercial disputes. In Asia, we see that Asian courts do not really present themselves as competing with arbitration, and they mostly present themselves as offering a merely complementary dispute resolution method. They rectify the shortcomings of arbitration. And in this respect, if I may just give an example that I borrow from the website of the Singapore International Commercial Court, but this is only an example. We see similar considerations also in the case of other courts. It is there mentioned that parties may be able to pursue their claims in arbitration, but they may prefer to resolve their disputes at the Singapore International Commercial Court in order to avoid some of the problems encountered in arbitration. And it's interesting to see which are these. So first, what is mentioned is the over-formalization, the delay and the rising cost of arbitration, so the judicialization, otherwise called, of arbitration. Then we see concerns about the legitimacy and ethical issues in arbitration, the lack of consistency of decisions or the absence of a publicly available jurisprudence, the absence of appeals, and the inability to join third parties, which was also mentioned today during previous presentations. I believe that this question, the dilemma competitors or partners, is a merely rhetorical dilemma. Whether competitors or partners, arbitration has influenced the establishment of these courts and their institutional and procedural layout, and we see that in the features of these courts. So let us see some of the arbitration features of these courts. These courts, most of these courts, with the exception of the courts established in special economic zones that are vested with exclusive jurisdiction over disputes arising within the zone, the rest of the courts mainly base their jurisdiction on choice of court agreements. So we see sometimes mentioned, reminiscent in a way of arbitration, that choice of court agreements are the jurisdictional cornerstone of international commercial courts. In the case of some courts, we see that the parties' agreement does not only establish international jurisdiction, but also subject matter jurisdiction. For example, parties at the Singapore International Commercial Court may agree that their dispute is international or commercial, and thereby place it under the court's jurisdiction. The withdrawn proposal for the Brussels International Business Court had a similar provision, but it was very much criticized by the Belgian judiciary. It was claimed that it will give parties the ability to circumvent the jurisdiction of the regular Belgian courts, and it will give rise to a domestic forum shopping. We see that in general, international commercial courts give parties saying in the design of the proceedings. Parties may choose, and it was mentioned also by Professor Yip earlier today, foreign rules of evidence or even soft law instruments. For example, at the Singapore International Commercial Court, parties can choose the IBA rules on the taking of evidence. Parties may prove foreign law on the basis of submissions, either oral or written. This is possible at the Singaporean Court and the Dubai International Financial Center courts. And this also finds its inspiration in arbitration. Also, the justification for expert evidence, so the lack of expertise, does not apply to these courts because they have foreign judges sitting on the bench. Parties before these courts have the right to appeal, with the exception of the China International Commercial Courts, because the China International Commercial Courts are divisions of the Supreme People's Court, the highest body, adjudicative body in China, and therefore its decisions cannot be appealed. However, international commercial courts, they emphasize that parties may either waive or limit the right to appeal. I think in European international commercial courts, that's nothing new. That's already provided for in some national civil procedure laws. We also find it at the Singaporean court. The Singapore International Commercial Court Committee report offered some examples, and it mentioned that the parties may limit the right to appeal to the grounds to refuse the recognition and enforcement of arbitral awards under the New York Convention. We also see international judges, mostly in the courts in the Middle East, in Kazakhstan, in Singapore. Also the China Expert Committee has foreign nationality judges, which except for expertise, they also instill some neutrality in the bench of these courts so that they can appease the concerns that they are national courts staffed with national judges and potentially favorable to their own nationals. Representation by foreign lawyers is also something that we find at these courts. It was a measure to incentivize foreign lawyers to bring their disputes before the courts. Another very interesting arbitration feature is that at the Singapore International Commercial Courts, parties may apply for confidentiality orders, but only in offshore cases, namely cases that lack a substantial connection to Singapore. And I think the most interesting feature of all at the DIFC courts, I don't know if it is still in practice, it was possible to convert a court judgment into an arbitral award. So the non-payment, so any dispute arising out of or in connection with the non-payment of a money judgment may be referred to the DIFC-LCIA Arbitration Institute, and it may be converted to an arbitral award. And in this way, the DIFC courts, they try to take advantage of the extensive territorial reach of the New York Convention, because at the moment we lack treaties that have such a big, so many member states. So the last part of my presentation, in general, we see that the common thread among all these arbitration features is party autonomy. Parties have a greater say in their proceedings, and by their agreement, although sometimes their agreement is subject to the approval of the court, they may design proceedings. Party autonomy, I think, is welcome. It may make proceedings more flexible, but at the same time, it could be time-consuming or a bit expensive. Now, three questionable features, I think the joinder of third parties that did not consent to the jurisdiction of an international commercial court. It was mentioned today, and we saw it also mentioned on the Singapore International Commercial Court website that I offered as an example, that international commercial courts are better positioned than arbitration joint third parties. I think there is a limit to that claim because, for example, if we look at Europe, these courts use English as a court language and they charge higher court fees than the regular courts within the country. Therefore, the joinder of third parties, if they do not submit to the jurisdiction of the court and against their will, I think could be an issue. It could be claimed that it undermines the right to a fair trial and create even recognition and enforcement obstacles. It is indicated that the NCC rules are very detailed when it comes to how you join third parties, what happens if they object, then the trial continues in Dutch, and so on. Private and confidential proceedings, we saw it in the case of offshore disputes at the Singapore International Commercial Courts. The justification was that because these disputes have a very weak link to Singapore, this weak link in turn weakens a clash with national public policy. I believe one could object that there is a transnational public policy, according to which public court proceedings have to be in public. Lastly, the conversion of judgments into arbitral awards. Doubts have been expressed whether this is a dispute, a difference under the New York Convention, and therefore whether it could be settled in arbitration. Thank you very much.
So thank you very much, Georgia, for really pointing out where the ICCs take from arbitration. The very last issue you mentioned is an issue meaning converting a judgment into an arbitral award that wants to circulate under the New York Convention. I do not think would meet the Article 1 requirement of the New York Convention that there be a dispute. But that's a completely different issue. Thank you for raising that. And I know that there are a few papers out there. This being said, I give the floor to Weixia.
Thank you very much, Chairman. Good evening from Hong Kong, and good morning and good afternoon to audience from various parts of the world. It's my great honor and pleasure to be invited to BICO. Thank you very much, Eva and Sandra, for having me here. It's also my huge honor to have Professor Franco Ferrari as the chairman moderator for my session, who has very kindly and very knowledgeably hosted my webinar at NYU yesterday. Now let me pull my slides. Well, I will try to reflect upon what has not been covered by the previous two speakers in their presentations. So what I'm going to cover in my next 8 to 10 minutes is to say about the interplay, not only between the international commercial courts and the international arbitration, but also among the international commercial courts per se, that have not been outlined in the previous sessions. Now, firstly, I would like to quote my forthcoming article at the Chicago Journal of International Law, which is entitled The Global Rise of International Commercial Courts, Typology and Power Dynamics. In my forthcoming article, I unpacked the myths of co-opetition, which I borrowed from the literature of international financial law. So as has been argued by Barbara, Dohmann, QC, and Georgia just now, so there are competition as well as collaborations. So this is what I borrowed from the literature in IFC, and then this is co-opetition, which has been very established in the international financial law. Well, this very interesting word is a combination and derives from the two seemingly conflicting concepts of competition and cooperation, or competition and collaboration. Or taking an example of Hong Kong Stock Exchange and then the Shanghai Stock Exchange. Whereas both are being argued as, the financial centers in China, Greater China, or Asia, they have different niche products. Well, the Hong Kong Stock Exchange, they focus on offshore RMB markets, where the Shanghai Stock Exchange, they focus on bonds and wealth management. So each developed its own complementary niche focuses. Well, in terms of international commercial courts, we can borrow also the concept of the international financial law. And in my article, I argue two different dimensions of co-opetition. First one is the horizontal level, which is among the ICCs, among the international commercial courts per se, not only in Asia, Europe, but also throughout the world. The other dimension is the diagonal level between the international commercial courts and the international commercial arbitration. Now, first, horizontal level, as Professor Ferrari has explained to you in his very masterful introduction, I will focus on Asia. Well, let me use the example from Belt and Road market, which was initiated by the Chinese government officially since 2015, where I originated from. Well, in the Belt and Road dispute resolution market, I have identified five very market-driven international commercial courts, which are the China International Commercial Court, the CICC based in China, the SICC based in Singapore, the IFC based in Dubai, QIC based in Qatar, and AIFC based in Kazakhstan. Obviously, they have co-opetition dynamics with common geo-economical and geopolitical aims to cater for disputes arising out of the Belt and Road Initiative roadmap. Obviously, there's very straightforward competition as to choice of courts. There's forum shopping in the international commercial agreements arising from the business parties. But also we will see there's different geographic focuses and different clientele bases. For example, CICC, where the jurisdiction I come from, is having more focuses on the Chinese parties and Chinese connections, including Greater China, Hong Kong, Macau, and Taiwan. The SEC has a very strategic role to play in the BRI ASEAN market, where among the 10 member states of ASEAN, Singapore is the very outstanding one with the developed economy. So it's pretty much like, stable out of instability. In terms of Dubai and Qatar, you will see this has a focus on the BRI Middle East market. And in terms of Kazakhstan, AIFC, Astana International Financial Court, it is intended to be for the Euro-Asian market, which I think is very ambitious. And just hearing Barbara's presentation, I do see there's a very huge increase in the caseload, 624, which might explain it's doing very well. Well, but I still see that there is a lot of room for regional collaboration to enable fine-tuning and niche offering. For example, in ASEAN, there's judicial roundtable. There's also ministerial level collaboration meetings by ministers of justice. I do see, and I do believe that, there's room for regional collaboration in the BRI market, dispute resolution market for these ICCs, which I have identified for more strategic collaboration. Now, in terms of diagonal level, in terms of, how international commercial courts, they are going to compete with international commercial arbitration. Well, a number of social scientists in the arbitration sector, they have identified the increasing juridification trend of arbitration in the world, not only in Asia, but also in other parts of the world. Especially in the common law jurisdiction, you see an increasing judicialization trend in arbitration, for example, in England, also in common law jurisdictions in Asia, like Singapore and Hong Kong. Well, very interesting. I find the reverse might be true as well. And then you see a very interesting arbitralization of the ICCs that have been taking place, in particular in Asia in the most recent years. For example, I use the SICC as an example, which has also been covered to some extent by Georgia's presentation. SICC mimics the features of international commercial arbitration. I just number 3 of them, which I think are very outstanding and that have not been covered by previous presentations. Firstly, the choice of SICC and the opt-in jurisdictional clause could have no connection with the host state, i.e. Singapore. So basically, you can have a choice of court agreement designating SICC having no connection with Singapore. This is very much alike what has been taking place in international commercial arbitration. Secondly, which I think is very important, is the mobility of the outcome of the international commercial courts. In that respect, the SICC has been using the international conventions in the field, namely the Hague Convention on Choice of Court Agreements, as well as the future Hague Judgments Convention, which doesn't require choice of court agreements as the precondition, so as to boost the global enforceability of the SICC outcomes. I have to mention here that, SICC and CICC, both Singapore and China, they are member states to the Hague Convention on Choice of Court Agreements. The difference here is that Singapore government has ratified the Hague Convention so that it has already taken effect, the SICC. On the other hand, you will see that Chinese government has joined the Hague Convention on Choice of Agreements, but the Chinese government has not yet ratified Hague Convention domestically, so that the Hague Convention is not really taking effect to the CICC judgments. Moreover, I see this as very legitimacy concerned issues, more social science driven, that SICC has been publicizing its commercial judgments on the websites. So it has been creating jurisprudence exporting, whereas other ICCs in the region as well as throughout the world can be looking at the SICC judgments. Certainly it has impact on transnational legal order, as I have argued in my Chicago Journal of International Law article. Well, another very interesting phenomenon and features I have identified is about the multi-tier dispute resolution, the MDR. I will wrap up very quickly. In BI Asia, you will see that litigation, arbitration, mediation, they have functioned all together to form an MDR network with greater diversity and flexibility. This is very outstanding in CICC's one-stop top-down multi-tier dispute resolution platform, where CICC has been linked with China's most market-driven leading arbitration institutions, as well as most market-driven leading mediation institutions. Very similarly, Singapore has top-down SICC, SIAC, and SIMC agglomeration trio. Well, I have the honor and pleasure of inviting Eva and Ipman, who are also on the panel today, to contribute to this book, where Justice Anselmo Reyes and me, we have been co-editing a book forthcoming with the CUP, which has been focusing on the multi-tier dispute resolution phenomenon alongside the ICCs throughout the world. I think I will stop here and hand over back to Professor Ferrari. Thank you very much for attention.
Thank you, of course, Weixia, for your comments that have linked even and expanded on previous ones. And we will be reading your Chicago law review article, okay? So thank you very much. And I give the floor to Sophie now.
Thank you very much indeed. And it is a great privilege for me to be on such a distinguished panel on such an interesting topic. My take is going to be, I'm going to look at the phenomenon and development of ICCs from the point of view of the arbitrator in international commercial arbitration and what that development means for the process going forward. I am of the school of thought that there's no reason to shy away from competition on this one. It is the market for international dispute resolution is a free market. And if there are new players, that's good news for users. What it does mean, and that's going to be my proposition today, is that international commercial arbitration has got some tidying up of its garden to do. And I'm going to say that as succinctly as I can. I would like to recall, perhaps to start with, we all know this, but it's easy to forget in modern times, the reach that international commercial arbitration has obtained at the expense of what used to be sent to national courts. We now have a private justice system that reaches into new territories such as obviously foreign investment, sports, competition matters, internet-related disputes, and now disputes such as climate change and blockchain. Many of these disputes have, in addition to the private interests, important high-stakes public interests. And arbitral systems have been therefore said to be, by noted scholars such as Professor Jose Alvarez, more autonomous, more numerous, and they have acquired a growing normative power, furthering the development of their own spheres of non-state normativity. And there is a noted school of thought in France, particularly, that considers arbitral systems to be autonomous, transnational legal regimes that are detached from the state legal system. Now, what that means is that reach has not come without some resistance. And that resistance has come from very recent and very high-level quarters. In 2016, the then Lord Chief Justice of England and Wales, Lord Thomas, made a very noted speech where he bemoaned the fact that arbitration had a negative influence on the development of English law and jurisprudence. That's one interesting take from a very authoritative and very arbitration-friendly quarters. The European Commission, as we all know, after initially embracing investor-state dispute resolution in the form of arbitration, has now successfully, I would argue, completed a complete sabotage of that system and now introduced a two-tiered court-related system, investment court-related system in its treaties, complete with an appeal on fact and law. And in parallel with that, the arbitral process itself, as is being evidenced practically every year that we have a Queen Mary University of London survey coming out, well, the arbitral process itself is making very little progress in tackling the problems that are identified very squarely by the Singapore International Commercial Court, which is time and costs, which is the lack of diversity in the composition of its tribunals, and which is essentially the sheer heavy procedural burden that it imposes on its users. So when the ICCs arrive as emerging as a direct alternative to arbitration, possibly as a co-opetition or a combination between cooperation and competition, time will tell. But certainly at the moment, Singapore positions itself squarely as an alternative to remedy the ills of arbitration. Then we have certain questions to ask ourselves, those of us who practice in arbitration. And so the questions that I would like to ask very briefly for discussion are the following. What is it that's left about the arbitral process to attract the 21st century user? Is it the freedom or flexibility to choose your decision maker? Is it the procedural flexibility or adaptability of arbitration rules and their cross-border, non-national legal nature? Is it the role or presence of the institution? Is it the ease of enforcement? Now, the enforcement point has been touched upon very pitifully by Georgia when she talked about, are we talking about something that can be amenable to the New York Convention? And the DIFC has boldly gone ahead and proposed that it could, and it's not alone, because obviously in the investor-state dispute resolution arena, that's what the European Commission is saying about the decisions of its two-tiered courts. Yes, it's going to be an award enforceable under the New York Convention because this investment court is a permanent arbitral tribunal under the terms of the New York Convention. So the ease of enforcement of arbitration may, I wouldn't say it's a thing of the past, but it certainly is encountering some pushback. Secondly, the freedom to choose your decision maker, always been a very great hallmark of arbitration, needs to diversify itself for sure, but that's a matter for the users and the institutions, certainly. And one must have to question whether that absolute advantage has become very relative due to the fact that several noted arbitrators are acting as judges of these international commercial courts. So you do get that know-how, you do get that experience, you do get that authority. Procedural flexibility and adaptability of arbitration over international commercial courts, possibly, but only in my view, if it translates into a real lessening of time and costs. We really have to make some work on that front. The institutions, what value added might they have on top of the international commercial courts that are backed by powerful political will and finances? That's an open question, and probably not a question for this panel, but for another talk. And at the end of the day, the reach that arbitration has obtained over the past decades might start to see an encroachment by the courts themselves. The synergy and cooperation, collaboration that Weixia alluded to, I think is an extremely interesting prospect. It is something that takes time. It is something that takes dialogue. What I wanted to posit is that as arbitrators and as users of arbitration, we have got to make a case for arbitration to be more competitive than it is now. Thank you.
Thank you very much. I have to say, I'm very happy about what you just suggested, Sophie. You acting as an arbitrator, of course, you also see where there are some issues with arbitration, and exhorting even arbitrators to do a little more, as well as institutions, by allowing competition is, I think, a very, very useful statement and suggestion. So thank you very much. So allow me now to, I have a lot of questions. I will not ask these questions. I will give the floor, of course, to the audience. And there is indeed one question. And the question is addressed to you, Barbara. The person asks whether, taking into account Qatar's well-developed arbitration experience, for example, in employment matters, there are any special tools to expand access to justice elsewhere in other jurisdictions. What did you find other jurisdictions could, for example, copy in order to promote what the ICC over there has done?
Give me one moment, I must deal with the battery. Right, okay. I had a battery problem. Can I say, first of all, Qatar does not have an arbitration center, and there was no question of Qatar arbitration experience. That was the Qatar International Court. And one way of facilitating access to justice, and I completely agree, a huge point, both for the international commercial courts and indeed for arbitration, is pro bono. And we have fought for years in Qatar, and successfully in the end, of establishing a pro bono system. And we have a pro bono also in Kazakhstan. Now, and a great deal of it, including in arbitration, and arbitrators giving their time for free. Now, that was not an overall answer, because you can't expect everybody to work for free. They have to earn a living. So that access to justice can only, I think, be improved for people, apart from having it absolutely free, to have it at a reasonable cost. And that is a question which it is well beyond the framework of this webinar to answer. But it is one that I think is of the greatest possible importance, because particularly in England, access to justice is just about gone because it is so expensive.
So thank you very much. Of course, apart from the employment matter referred to by the person who asked the question, and this is an issue in arbitration as such, because several courts in different countries have now had to deal with the issue of impecunious parties, not parties unwilling to pay, but impecunious parties, and it has led in different countries to different solutions. Some countries even suggested something like a right to arbitral access, right to arbitral justice. And that is, of course, an issue that relates to what you said, Barbara, whether arbitrators have, under certain conditions, to work for free or not. For example, what if the counterclaimant is impecunious? Do the arbitrators have to take the counterclaim into account? There is a very famous case, of course, in France, and it looks that if the counterclaim is closely linked to the main claim, even though the rules require the counterclaimant to pay in advance on fees, but cannot pay, the arbitrators have to take a decision. So as you said, Barbara, this is for another day. So I really thank you all, of course, for your thoughtful presentations. We are nearing the end of the time slot we were granted. So thank you for being with us. Thank you to Eva for inviting me as well, to allow me to be with you. Eva, I give the floor back to you.
Yes, thank you very much. If you allow me to ask one last question that has been burning for a while, I found very interesting that Sophie said, or asked the question what attracts people to arbitration. And she mentioned a list of points that we all know, including the ease of enforcement, which is a very important point. The question would be, is the fact that we have the Hague Judgments Convention of 2019 going to change the landscape a little bit? So would those international commercial courts maybe get more cases if this is a convention that is widely accepted? What is your impression of the situation in that respect? It's an open question for all of you. And Sophie first.
Sorry. My impression is that obviously the New York Convention has got the advantage of a huge acceptance over the past 50 years. So it has a good leg up, but for sure, the Hague Convention and the Singapore Convention, for that matter, for mediation as well, is going to my mind, change the landscape. I don't expect to see that within the near future, but there's no question that it offers, again, an ease of enforcement and an ease of circulation of decisions at a very high quality decisions at the international level that is to be welcome for international commerce, for sure.
Yeah. Would I be permitted to say just one point on what was cited of John Thomas's reference to the lack of precedent in arbitration? This isn't quite right, you know. First of all, the ICSID arbitration awards are published. Everything to do with ICSID is public. And there is a great deal of precedent being created that people can cite. In Kazakhstan, awards can be published with the consent of the parties, it is true. In other places in Europe, awards can be published and they can be neutralized up to a point anyway. And you can get a lot of reporting in the arbitration journals and generally as to what is going on in arbitration. I do think it is wrong to suggest that this is all, you know, non-transparent and impenetrable. Having said that, I would add that once arbitrating parties are people who want their dispute resolved, they don't really give a fig about the development of commercial law. We do, but we do inform ourselves pretty well what goes on in the arbitration world.
I will jump in, Eva.
Yes.
I think, well, as I've mentioned in my presentation, Hague Judgments Convention and its wide admissibility or wide applicability in the world will definitely pose a challenge to international commercial arbitration. Actually, as I have argued in my paper, there are three pillars of the cross-border international commercial dispute resolution in the world today: cross-border mediation, cross-border arbitration, and ICCs, representing by some of the leading market-driven international commercial courts. I think the main side effects of international arbitration today is the costs. Well, I have to confess that enforceability is a very big selling point, but the costs, as you see the example of SICC, the judges sitting on the SICC bench, they are capped at a certain rate on a daily basis. So when I'm sort of like doing comparative research or, you know, empirical study, I would see that, you know, that certainly pose a big threat to arbitration in certain jurisdictions. But having said that, you will see that in the course of building credibility of some emergent international commercial courts like China, like CICC, you will see that even though it has been established, but the thing is that it doesn't have too many cases. And I think it will take quite some time for certain international commercial courts to build credibility, to attract cases, to make the parties feel very comfortable to choose it for various reasons. So for a certain period of time, you will see this as a case-by-case analysis. For certain ICCs, it will be a challenge, I mean, between ICC and ICA. But for other ICCs, it will be more our collaboration, complementary perspective. So it's not really all across the region or the world, but it's more region by region, case by case analysis. Thank you.
Thank you very much.
And now me to also add something in this respect. I think Sophie is completely right. Whatever will happen, even if we were to be very positive about the effect of the Hague Convention, it will not happen today. It will not happen tomorrow. In our lifetime, there will not be, in my opinion, a real competition. Apart from the number of contracting states, that's a different issue. But just think about what lawyers will consider. If they rely on the New York Convention, they will consider 50 years of case law on the New York Convention itself, on the concept of what validity is, incapacity, how the relationship between an arbitrator doing something that's not in accordance with an agreement on procedure, and all of that, public policy and so forth, public policy for arbitration. And while the Hague Convention will not have that benefit of a case law setting in which it can or will be embedded. So yes, it is welcome, absolutely yes. But before it really becomes a competitor, in the sense we may understand the word competitor, it will take decades, not just a few years. And before I give, I see that Sandra also would like to ask a question, and I noticed that we have time. So Eva, if you want to give Sandra the floor.
Yes, of course.
I'm sitting next to her, but we have a camera that looks at Eva now.
I did not know.
The screen here, because of course we're nicely distancing. I agree totally with you, Franco, that it will take tens of years before we are there. And though, of course, in the area of recognition and enforcement of judgment, we do already have experience. Of course, we have our experience in Europe, but for that, we don't need a judgment convention, but also outside of that, we know a little bit what will come from the US and from certain other countries. So it's not completely new. And compared to the New York Convention, we may have a little bit less or may need a little bit less time to build. But my question was mostly to Barbara, but perhaps also to the others, because I think you mentioned it, that the costs came up a couple of times, are so extremely high, but they're both very high in arbitration and even higher, but also, of course, in the courts, and especially if you look at English courts. In the Netherlands, the Netherlands Commercial Court, there the fees are also substantially higher, but then we're talking about 10,000 and 15,000 euros, but that's very high compared to our normal fees in the Dutch courts, even for higher commercial cases. But how do you think this compares, and is then the cost aspect an opportunity for international commercial courts, also knowing that the Hague Judgment Convention will start to become applicable in the next years? Is that a good opportunity, or should we rather look, or both, at maybe lowering or trying to reduce the cost in arbitration? How do this cost aspect relate?
May I suggest that one way forward is, and it's only one, is the amount of recoverable costs that an international commercial court and an arbitral tribunal allows. Most arbitral tribunals by now that I'm associated with are very conscious that, you know, the arbitrators will cost maybe so many tens of thousands of dollars as a whole for the whole case, but the legal costs of the parties are counted in several millions. That is true. You just don't make them recoverable. And that will have a salutary effect, except that there's a perfectly valid argument for saying, well, that's desperately unfair on the party who has succeeded and who shouldn't never have been sued or whatever, you know, there is that counter argument. So you probably have to give recoverable costs, but you have to balance in relation to the merits and how much. But that is also in the court system and in the English court system, a terrible problem that it has become more or less automatic to get a major part of the legal costs recoverable. And it has been terrible as a result on access to justice. You just know that you can't afford to go to court because you carry the cost risk if you lose of paying the costs of the other side. And that I do think has to do a lot with the judiciary having to get together. No one judge can do this. And there has to be guidance also as to what we can do in order not to have the legal costs of the parties be in so many millions.
Thank you very much, Barbara. I think this is now the moment. Franco, you have been perfect with timing. I've extended this slightly, but we have actually a longer break. So I would, first of all, thank all of you for your very interesting contributions. Thanks to the speakers, thanks to our chair. And I would see you again at 3:15 London time. So again, as before, you can just unmute and stop your video and reconnect in about 20 minutes. Thank you so much.
Thank you. Thank you to everyone.
Very much.
And I thank our chairman very much.
Thank you. Bye.
Thank you very much.